with that said, I think you guys are in for a treat. We are pleased to have Ken Gerard talking about the how to manage open records requests and the Open Records Act within Georgia. And I'll let Ken tell you a little bit about himself. Thank you so much, Ken. Take it away.
Thank you, Dan. I appreciate being afforded the opportunity to come and present here today to all of you out there watching by way of this webinar. Great to see you. I am Ken Gerard. I'm with the law firm of Gerard & Davis. I'm actually coming to you from Cumming, Georgia, in my office, and have been practicing governmental law for around 30 years, knocking on the door. I'm getting older, and have been working with the Open Records Act for just as long, and have quite a bit of experience both teaching this, practicing it in my role as county attorney in various jurisdictions, and even worked with some of the members of the General Assembly in 2012 when the last big rewrite of the Open Records Act occurred. And I would suggest to everybody that watching this that there is probably no law that is more fundamental to how local government operates, at least from a transparency and accountability perspective, than the Open Records Act. So to all of you who are taking time away from your day to come and watch this, I think it's going to be time well spent because this is such a foundational topic. And so we're going to go ahead and get prepared. We've got a lot of slides to go through, and here's kind of what I would propose. Dan and I were speaking about this before the webinar began, and that is I particularly when I lecture live, I very much like to hear the questions in real time, because I believe they elicit other questions from people in the audience, and that in fact is its own form of education. Here it's a little bit different, and so as questions begin to come in, I want to make sure that I get through the slides. Unfortunately, fun fact about me is I typically get so involved in some of the questions coming from the class that I don't get through the slides, and I want to make sure I get through the slides today if at all possible. So let's go ahead and start. And Dan, do you want to mention that one request before I get into the slides?
Yeah, if we can. The question is, I have a contract investigator retained by the Defense Counterintelligence and Security Agency requesting a restricted incident on an individual for employment with the military. The individual did sign an authorization for release of information form. Is this information available to be released?
Right. So, and Dan did mention this question to me before we began, and here's my response to that. That almost really isn't even an Open Records Act request. You've got a entity that is probably trying to get some sort of a security clearance that has made a request for information involving probably a former city or county employee. And here is the thing: the city or county employee in that fact pattern has actually given their express permission for this information to be released. Therefore, I believe it can be released. The only thing that I want to make specific mention of, and I thought the question mentioned this, and if it didn't, still good food for thought, is that while an individual has the right to authorize the release of their own information, think HIPAA, think this fact pattern we've got in front of us, certainly individuals can give authorization for their own information to be released, and then the government, I think, has the right to release it pursuant to the parameters by which the individual authorized it. I don't, though, as that employee, I don't have the right to authorize the release of someone else's information. And what I mean by that is, because I thought a component of this question is there might be information within the release that implicates other employees, and if that's the case, I would redact that. Again, I think you have the right to accept an authorization for release, act in accordance with it, provide it to this, what appears to be a legitimate, lawful investigation, presumably to give someone a security clearance, but I would redact information that affects other individuals that may impact or have confidential information about other individuals if they have not released it. So that's my thought on that one. And if there's a follow-up question, get it to Dan, and I will get you a further response offline. And this is a good place for me to say too, that is, as your questions come in, particularly with the Open Records Act, a lot of times the questions may be very factually nuanced, And so sometimes a one-size-fits-all answer doesn't actually apply. So that may be a reason why I say, let's talk about that offline, because I may have more questions to ask you to make sure I get your answer correct. All right, let's see if we can go forward. All right, I hope everybody can see the slides as I'm going through them. And I'm going to go ahead and just start with sort of the fundamentals, and then we'll move on to more advanced topics. The first thing, again, I want to repeat is that we're talking about the Open Records Act. The Open Records Act is sort of the mirror image, or at least the different side of the same coin, of the Open Meetings Act. And both of them are sort of colloquially known as the Sunshine Laws. And the objective of the Open Records Act is to promote transparency and confidence in government. And so the first thing in figuring out how to respond to an Open Records Act request is to make sure you have an appreciation of what it covers. And so, we can talk about this in great detail, but here I have in front of you a slide. I move that up a little bit. But what I can tell you is this. This is in the statute. This is in the Open Records Act. You can see the official code of Georgia, annotated 50/1872. So that's the actual citation to the first chapter of the Open Records Act. And the first thing out of the gate is there's a definition of what a public record is. And let me just go ahead and say it is broad, and that is on purpose. We can go through this definition and talk about what it means to be a document or a paper or a letter or a tape or a photograph or a computer. That's great, and we can talk about that. But when you see a series of words like that in a statute, what the General Assembly is attempting to communicate is that it's basically every tangible medium of communication. It's everything that can communicate data, including electronic data. So when you're thinking about whether something is subject to the Open Records Act, I would propose to you that thinking about the actual medium of communication is not as important as the underlying words I have on this slide. And that is the document, is the spreadsheet, is the plat, is the application, is it prepared or maintained or received by the agency? And the agency is going to be your government, your city, or your county, or perhaps if you're a part of an authority. Was it prepared or maintained or received by that agency? So, for instance, just to give you a simple rule of thumb, if you're talking about a budget, well, the annual budget was prepared by the government. Easy. Therefore, it's subject to the Open Records Act. Was it received by the agency in the course and scope of governmental operations? Well, was it? Was it an application for a new zoning? Was it an application for a business license? Was it a citizen or constituent email delivered to one of your city or council members? If so, and if it was received in the course and scope of the operations of the agency, then it is going to be a public record. And I will further tell you that the Open Records Act is designed to be liberally construed, and that is not a political construct of liberal. That's talking about expansively. It is intended to be expansively construed, and that if there isn't a doubt, a reasonable doubt as to whether a record falls within the purview of the act, or whether a record should go out, or whether a record is confidential, if there's a doubt, if there's a reasonable question, the law tends to say it should go out, it should be released. It is a document subject to the act. The law sides on the errors, if you will, commits error on the side of the Open Records Act applying. Okay, so that's a good foundational document for us to get comfortable with. All right, so we're going to go right in now to a little more of a sophisticated topic, and that is how or what is the appropriate format of an Open Records Act request? In other words, what can and should we expect from our citizens and individuals that are making Open Records Act requests? So first of all, the statute does contemplate that an Open Records Act request may be made orally or verbally. In other words, it can just be a spoken request. But I will tell you, and I suspect that your experience will agree, that most Open Records Act requests today are received in writing. And I would hazard that most of you would say that they are either done by an email communication to your government or they are done perhaps if you have a dedicated portal for Open Records Act request. That is another way. I know the statute still talks about facsimiles, and if somebody out there is really using facsimiles for Open Records Act request, I want to see that, because that's got some age to it, the notion of using facsimiles. But I suspect that the lion's share of everyone are receiving written Open Records Act requests, and I would submit to you that most of you are probably receiving them either through email or vis-a-vis a dedicated portal, and that's fine. And of course, I don't have to tell you that a written Open Records Act is far superior to a verbal Open Records Act request, because anything verbal gets lost in translation, is unclear, hard to keep up with, what was the date that it was received, just very difficult to really build an enforcement and compliance model around verbal requests, which is why, by the way, if you skip all the way down to the bubble at the bottom, is that the Open Records Act does have enforcement mechanisms, whether it's enforcement mechanisms through the State Attorney General's office, whether it's enforcement mechanisms through a private civil action against the government, or whether it's even some of the misdemeanor citations. But what I can tell you is if the citizen has made a verbal Open Records Act request only, none of those enforcement mechanisms apply. So again, the General Assembly is basically saying, yes, you can make one verbally, but if you make it verbally, there's no enforcement to be had. So you can only enforce if there is in fact a written request. Now, the second bubble on this slide deals with sort of I'm not going to say it's evolving, this has been in the law for a while, but not a lot of governments, or not as many governments maybe as should, have taken the Open Records Act up on this, and that is the fact that an agency may require that all written requests be made upon, and then you can see on the right hand side of the bubble this list of individuals. And for purposes of this discussion, let's just talk about the one at the very bottom, a duly designated open records officer of an agency. So in other words, what the Act anticipates is the government, the city or the county, may adopt, I would recommend by resolution, that John or Jane Doe is going to be the duly designated open records officer of the agency. And if you do that, the thing that's interesting about doing that is if you do that, the response deadline does not begin. The 3-day response deadline does not start until the Open Records Act request is actually to that individual that has been so designated, which is why the Act also contemplates that you have to prominently display who that individual is. Now, some governments have done that. They have transitioned to truly having what I'm going to call an open records custodian. And they have truly sort of transitioned to that model. A lot of benefits from doing it that way. Number one is you're able to bring in presumably maybe a dedicated specialist to help with your open records compliance. Number two, it frees up a lot of other, let's think department heads or other department level folks that are otherwise perhaps getting inundated with Open Records Act, and actually moves that away to one individual. And that's great. I think it also lends itself to a consistency of response. I've certainly seen governments where if they send an Open Records Act to one department, they're sort of handled in one way, and then you send an Open Records Act request to another department, and it's handled in a completely different way. And that can be less than ideal. So if you have a central one-stop shop, if you will, there are a lot of, I think, benefits to doing that. One caveat is that if you do designate that individual, a single person, as the Open Records custodian, and the Open Records Act request does in fact duly come into whatever email or portal that routes it to that person, the Open Records Act is clear that if that person is on vacation for 2 weeks, that doesn't mean that the response is delayed for 2 weeks. So we would just need to be mindful that if that individual has been so designated, then you're going to need to monitor whatever tool it is that you're getting the Open Records Act request to that person. So in other words, you can still give a timely response. All right, so this is, again, and I think if you were to ask me what the big takeaway is out of this slide, it would be think hard about whether it might be appropriate for your government to have an individual designated as the open records custodian, because it may serve a lot of benefits for your government. All right, so talked about perhaps the who it goes to. With respect to the actual request itself,
Ken,
yeah.
Before you get into this slide, here's a few questions for you.
Yep.
Does an harassment and/or bullying allegation investigation fall under the open records request after the investigation has been closed?
Yeah, the answer is that's actually an exemption under 501872. And so I'm going to go ahead and, when I get a question like that, I'm going to frame what I'm answering. So what I'm answering is there must have been an allegation internal to this agency of an allegation of harassment or abuse or bullying, and the agency conducted an investigation into that allegation. What the Open Records Act says is for those sorts of internal investigations of misconduct, that the documentation involving the investigation is in fact an Open Records Act, subject to the Open Records Act, 10 days after it has been released to the agency for a final decision. And the reason for that, in other words, you may say, so that what, the investigation is completed and then it's turned over to the county manager. The investigation is completed, it's turned over to the city manager for action. The investigation is completed, it's turned over to the Board of Commissioners. Yes. And the idea is that those entities, the city manager, the county manager, the Board of Commissioners, the city council, should be given a reasonable amount of time to make a decision as to what, if anything, they want to do with the results of the investigation, but before the documentation is released and then becomes public, because then everybody becomes an expert in the community about what needs to be done, and the decision makers who really matter need to have just an opportunity to consider it before it goes live. So the answer is, again, assuming that I framed it correctly, the answer is going to be yes.
A couple other questions here. What if the ORR is for records the city doesn't have in its possession because it is handled by a third-party vendor?
Right. So that's a great question, and the answer is if the documents are being retained by a third-party vendor, presumably, and again, this is me filling in the blanks, but presumably being funded by the city or county. In other words, the vendor is being funded for the city or the county. Then it's very clear that there is an obligation to produce those records. Now, what I have done in the past is when I get a request, let me just give you an example. I get a request, an Open Records Act request for perhaps documentation involving maybe an intersection project or some sort of a contracting project. And we, in fact, the county or city I'm working in and representing has a third-party contractor that's doing that work. I will send the Open Records Act request to whoever is the front person for that vendor and say, listen, you need to provide this information. If you want to provide it to me, that's fine, and I'll get it to the requesting party. Or if you want to get it to the requesting party themselves, you can do that. But the Open Records Act is very clear that documents in the possession of a private entity that are otherwise engaged in the performance of activities on behalf of the government is subject to the act. And so you don't get away, you can't avoid responding simply because it's some private entity. And just to give you a real life example, from time to time, my office gets Open Records Act requests related to certain matters that I may be working on with one of my governments. And if it's not attorney-client privileged, and even though I'm a private law firm, I have to respond. Why? Because they remain government documents because I'm retained by the government.
A couple other questions. How about having a third-party vendor such as billing service? Do they need to be designated?
Do they need to be designated? I'm not sure I understand that one, Dan. Is it not a billing service related to the Open Records Act? It's just a third-party billing service that's doing work for the county or the city?
I believe that's the question.
Yeah, if the answer is, do they need to be designated as the records custodian? No, I don't think I would do that, because that relationship may not last long enough, nor do I think that's really what the act was contemplating with respect to the designation of a records custodian. No, I don't think that's true. I think if, for instance, in that jurisdiction, if they had a records custodian that was in fact a city or county employee, and they got a request for records from related to documents held by that third-party entity, I would have the records custodian work with the third-party entity to assemble the documents and then provide them in the ordinary course. That would be my recommendation on how to handle that.
And then a final question, and I'm probably just going to let you use the slide because we're going that. But do you have any concerns for departments that have begun using a dedicated software-based portal for open records that is some way acts to replace the official designated open records officer? The official custodian has access to the software, but the staff wants to direct all requests as much as possible through the transfer or through the portal rather than direct contact with the custodian.
Yeah, that's an interesting fact pattern, and that almost suggests that there's a little bit of an internal incongruity between how they're handling Open Records Act. So what I would say, just hearing that facially first blush, I would say is if you've set up an electronic portal and you're routing the documents through the portal to, let's just say, department heads and sort of bypassing the records custodian, you may want to rethink the need for the records custodian, if that makes any sense, because at least my thought on the records custodian is they are supposed to be in charge. I mean, I think the objective of the act in setting up the records custodian is that is the go-to person. That's sort of the tip of the spear in engaging the community on Open Records Act, and I view that as sort of that's supposed to provide the continuity, the seamlessness in the response, consistency with respect to redactions, etc. But if you've got a records custodian and are still like blasting those to all the departments, that seems a little bit incongruous to that. And again, I know I'm getting a little bit maybe off the question. Unless it goes to the departments, they then prepare the material and get it to the records custodian to provide the actual response. That was not built into your question, but that would be a little bit of a better approach to that if that's how it's handled. But I will say one more point, and then I'll be quiet on that question. I think, though, that if they've got the portal and it's going to all the department heads, and yet they still have that records custodian, you're missing, again, in my thought, one of the benefits of having the centralized records custodian, which is taking some of the burden off those departments and manipulating or managing all the timelines and the cost and et cetera. Again, if you're going to go, I tend to be sort of a in for a penny, in for a pound. If you're going to set up the records custodian, give that individual enough resources to handle it, and then let them handle it, let them do the work. Not that.
So we have a couple more questions, but I'm going to let you go through the PowerPoint, and then we'll interrupt at the end.
Fantastic. All right. And again, great questions, folks. Those are some good masterclass questions. With respect to the level of detail, this is a tough issue. And so for those of you who are in fact Open Records Act request custodians or otherwise engage them routinely, you know why this is a difficult topic, because a lot of Open Records Act requests are unclear. A lot of times citizens, and this is not a knock on citizens are running their lives and doing what they need to do, but a lot of times citizens don't even really know the right language to use when they're asking for certain things. You may know what they mean or what they want, but sometimes they're not sure or don't have the right nomenclature. And that can be a little bit of an interesting point is, do you work with a citizen and you try to get them steered to where they need to be, or do you simply, blindly just look for exactly what they requested and go no further? As you might suspect, I tend to be more of a, listen, we should reasonably try to engage with our citizens. The whole objective of the act is to provide transparency, accountability, confidence in government. And I don't know that those objectives are necessarily achieved if we're overly pedantic or hyper-technical in how we review stuff, such that we're, I'm not going to say playing games, but you get the idea, such that we're sort of purposely not being helpful. I will suggest to you, however, that some of you probably have frequent flyers or filers that you just are sort of over, and you feel like they sort of abuse the act, and you don't want to really go out on a limb and help them because did that last week and you've gotten 17 Open Records Act since. I get that. So again, I think you just have to use your best discretion when you believe that you need to try to help somebody get to where they want to be from the perspective of open records. I will also tell you that we live in an age where a lot more people are used to engaging their governments online. And I'm a big proponent that the more documentation that we can put online forward facing, the less Open Records Act we have to deal with, because the more you can go in and look at the zoning file, the more you can go in and look at the engineering file or the water file, that's just one less Open Records Act you have to fool with. But I digress. Let me get back to how much detail should be in a request. For most Open Records Act, a lot of the times it is clear what they want. I want this hydrology plat. I want this zoning file. I want the 2022 budget documentation. I get that. We can provide that. Where I see problems with the clarity and the succinctness of Open Records Act is when they are asking for electronic communications. The bane of my existence with respect to open records is emails, texts. I would now sort of add to this slide and say maybe social media posts online to the extent that they arise or are generated in the course and scope of government business. And the typical problem I have with requests for electronic records is their breadth, their scope. A lot of times individuals will not put in dates, like date ranges of when they are asking for this sort of electronic information. A lot of times they will not put maybe who the recipient or who the deliverer was. They will leave that blank, and they'll say something like this: please provide me all emails in X county that contain the keywords roads. Like, really? Like roads? I mean, that's going to generate like 10,000 emails probably a week. And so the law in 2012 was changed to include this language that's in the last bullet there. Requests for electronic messages, emails, and texts should contain information about the message that is reasonably calculated to allow the recipient to locate the messages sought. All right, so unfortunately, it contains the word reasonableness. Lawyers love reasonableness because we can fight over what's reasonable all day. But I get the point. And so when I receive an Open Records Act request that is for uniquely electronic data, emails, and text messages that doesn't contain any of those guardrails we talked about, that doesn't contain any date ranges, that uses these very broad terms that are going to capture way too much information, we have two options. One is that I'll have my team respond to the request as drafted. In other words, we'll get with the IT department of the county or city I'm working in. We'll run the query based on the search terms provided, and lo and behold, it's going to generate 30,000 emails. We're going to have to print them all out and redact them. So you're looking at $7,000. That's a hypothetical, but you get the idea. That's exactly how that can work. But then what we can put in our response letter is the Open Records Act contemplates that you will provide us sufficient information such that we can reasonably locate the document we're requesting. So in order to avoid this expense and in order to winnow down the breadth of the cost associated with it, we would ask that you provide us maybe a narrowed search range or a narrowed search query so we can have a better opportunity to get you what you're actually asking for. Some folks will not do that. Some citizens will not work with us on that, and they just want to do the huge fishing net. A lot of folks will. A lot of folks don't have the money to spend, and as long as the pre-retrieval estimate is in good faith, then I think we have every right to put that in writing and ask them to be responsible for it. But I do like the optics of giving them an opportunity to narrow their request, because what that shows to the requesting party and to the Attorney General, if you draw a complaint, is that we were trying to meet them halfway. We were trying to meet our citizens and make the request more manageable such that they could actually respond to it. So I do like that language in the Act. I do incorporate it into some of my letters, and I think that it helps. It helps engage the community on electronic documents particularly. All right, so again, just another point out of the statute. All public records, as we know, is defined very broadly. We've already gone through that slide. Shall be open for inspection and copying, except those which by order of a court of the state or by law, and it's the or by law that's probably the one you'll spend the most of the time worrying about, are exempted from disclosure. So the first point I want to raise here is the notion that the Open Records Act request does contemplate actual laying eyes on the original document. It's true. That's what it contemplates. The citizen actually gets to view the bona fide original documents. Now, I will tell you that 99.999% of citizens have no interest in that. All they want is a copy, which brings me to my next point. We have the right, and of course, we sometimes have the obligation to copy those documents for them in whatever format that is most reasonably economical. But they have the right, should they want to bring in their own copying equipment. And I remember getting a phone call one time from a fairly exasperated official who said that there were like 3 people in his lobby with their copiers. And his question was, they've come here looking for records, what do I do? And I was like, well, find them an outlet, plug those in, and let them, make their copies. And of course, their position was, look, I can make copies and cheaper than you'll make copies for me. And my position to the gentleman that called me was, it's going to save your toner cartridge. So, but all kidding aside and all fun aside, I get it. That was a unfortunate situation. Obviously, he was worried about, just the intrusion into the operations of his government caused by these folks bringing their own devices onto his property. But I had the unenviable task of having to tell him that that's allowed, under the act. It doesn't happen very often. I see that very, very, very infrequently, but it is important to know that it is available under the act. All right, so if I was to identify what may be sometimes the most challenging aspect of the Open Records Act, I think I would probably liken that into 2 different arenas. I would say that one, all of the exemptions to disclosure under 501872 is one of the more challenging aspects of the act. But I would also say that the time period to respond is another challenging part of the act. And so let's talk about that. How long does the agency, which is you, have to respond? A reasonable, there's that word again, a reasonable amount of time to determine whether or not the records are subject to access and to permit inspection and copying. But in no event shall this time exceed 3 business days. Now, important food for thought, because I can't tell you how many times I've received an Open Records Act request come blowing in my door, and it's from somebody that basically it's almost a threat. I want these documents in 3 business days, and they'll cite the code. Well, the code doesn't really say that. What the code says, and we're going to talk about the various permutations of this, but what the code says is that we have to provide them a response within 3 business days. And that does not necessarily mean the records in 3 business days. Now, I want to be clear. If the records that have been requested are public documents and they are obtainable, reviewable, redactable, and producible in 3 business days within the other functions that you're having to fulfill and with all the other Open Records Act that you're otherwise engaged in, then yes, you need to provide them in 3 business days. And again, I go through this just because it's helpful, but remember it's 3 business days and your clock begins to tick on the business day that you receive the request. So if an email requesting records comes in at 3 o'clock on a Thursday, 3 p.m. on a Thursday, then yeah, that's your first day. That's the date you get it in. And so the 3 days is, you don't count the Thursday, it's Friday, you skip the weekend, Monday and Tuesday. So your 3 business days would be that Tuesday. Now, same fact pattern, except that the email came in at 6 p.m. that evening when your county or your city is closed for business. I don't count that day. The date you receive that email is the next day. You receive that on Friday, you skip the weekend, and so you count Monday, Tuesday, and Wednesday. All right, so that's the way you count those 3 business days. And again, you skip intervening weekends, and you skip intervening holidays where your government is closed. All right, so let's see if we can go into now the actual response itself. So what to do if records are not available in 3 days? And again, this is actually a fairly likely scenario because, first of all, we're all busy. Everybody's busy. Some of you that may be open records custodians, believe it or not, that Citizens Open Records Act request is not the only one you have to deal with. There's more than that. And so many times the situation does arise that you simply just functionally cannot get it done in 3 business days. So let's walk it through. If you determine that there are responsive records to a citizen's request, and that's going to be the case a lot of times. It is a little bit unusual that a citizen makes a request where there truly is nothing in the county or city that is responsive. But I've seen it, but not a lot. So if responsive records exist and those records are subject to public disclosure, and there are records that are not subject to public disclosure, and the one I always latch on to because I love it is the attorney-client privilege documents. They are generally not subject to public disclosure because that's the way I engage and provide guidance to my client. But if you determine they are, but the records cannot be available within 3 business days of the request. And again, that happens a lot. The records may just be difficult to assemble. You may have to be working within multiple departments to get the records assembled. They may be in offsite storage. They may be being retained by some private vendor that you're trying to shake them loose from the vendor. There's all sorts of reasons. I would suggest to you the reason that is mainly provided to me as to why we can't get the records is simple volume. There's just so many of them that have been requested. So in that situation, again, that does come up all the time. The obligation of the government is to provide a written description of those records together with a timetable for their inspection and copying, and that needs to be provided within 3 business days. Now, with respect to the time frame, that can be a week, it could be 2 weeks, depending upon the request and the scope of the request. I've seen it take a month or so. And again, it just needs to be reasonable. It needs to be made in good faith. You should not give them a protracted window of production in order to accomplish some bad faith purpose or to otherwise sort of avoid bad publicity or to avoid what may be in the documents. It doesn't really work that way. It's got to be in good faith. But it is okay to tell a requesting party that the records are not yet available, but you have to provide something within 3 business days, and it needs to be, if they're not available, a timetable for production. So here is our nice little flow chart for you, and hopefully this will be of some utility to you. So number 1, sort of a yes or no. What are our options for response? If there's no responsive records, advise them. And again, I do recommend that we have a paper trail. So if no responsive records, that doesn't mean just throw up your hands and say, okay, no response at all. I do like a response to go to the requesting party saying there are no records available. If records exist but cannot be assembled in 3 days, then you produce, as we mentioned in the previous slide, the description and timetable within 3 days. And in that timetable, you will set the date of your likely production. Now, can it occur that that date that you set in the future for production gets to come near and you still can't meet the mark? Can you set it back further? Yeah, you can. I don't think there's anything wrong with that. The key, though, is that it needs to be in good faith. But I think that if there was an enforcement action and you're trying to show the court, or if there's an enforcement action and you're trying to explain to the Attorney General why you needed additional time and you can justify that, I think that's fine. I don't think the Open Records Act is supposed to be punitive. I don't think it's supposed to be a big gotcha by citizens, trying to break the back of the government. I think it's supposed to be a method for ensuring transparency and confidence in government. And so long as we are engaging in good faith, I think you'll be fine. Now, If the records are immediately available, let me just give you a really easy example. If it's just like a couple of meeting minutes or meeting agendas, produce those in 3 days. There's not going to be much, if anything, ever to be redacted in those documents. They should be immediately available. It shouldn't take a whole lot of digging to get those, but go ahead and produce those in 3 days. Also, the Open Records Act makes great provision for redacting or withholding certain sorts of information or documents. And the statute is 50/1872, and it's got just paragraph after paragraph after paragraph after paragraph of information that does not need to be produced and may in fact need to be redacted or somehow or another. Some folks use electronic redaction now. Some are still using a Sharpie and writing the Sharpie to redact. Either way is fine, so long as the end product is you can't read the data. And those exemptions are significant. They can be challenging to comprehend. For instance, one of the exemptions is anything that is confidential under federal law. Well, that's a fairly significant exemption to the Open Records Act. And I will submit to you that I don't know everything that is conceivably confidential under federal law. So it can be a bit of a challenge, and take it on a case-by-case basis. But just be mindful that when you finally produce the documents, this is key, when you finally produce the documents, the law not just expects, but demands that you will identify the specific paragraph in the Open Records Act that allowed you to not produce certain documents. And you have to identify them all the way down to 50/1872A13, the subparagraph, or 17 or 22. You've got to be very specific with respect to identifying why we did not produce documents. Now remember, that is not necessarily in your 3-day response, unless your 3-day response is the records. It's when you produce the records, you must identify the exemptions. And of course that makes sense. If you're giving a pure timetable for production, that means you've not generated the documents yet. Well, how can you identify the statutory exemptions if you've not even seen the documents yet? So the law does allow you to wait until you produce, and then you need to identify. So the Open Records Act also contains a fee shifting mechanism. And the objective of the fee shifting mechanism is to allow governments to recover some of the cost that they expend for providing this information. So here's how this works. You get an Open Records Act request in the door. And of course, you're going to read it. You're going to try to figure out, first of all, if it implicates government documents. We're going to assume that it does. And then you're going to, if you're the Open Records Act custodian, you may then circulate it to the various department heads or the custodians of records in the other department branches that you believe can assemble the documents. Okay, and that's fine. But if the cost, if they all kind of write back to you and say, Mr. and Mrs. Records Custodian, this is going to take a lot of time. We're going to have to dedicate a full-time person here to spend several hours, producing this, and then we hear from another department that's going to cost them, the same amount of time. So all of a sudden now you can see that some costs are rolling here. You can see this is beginning to become expensive, and we'll talk about how you assess those costs. But just a real quick is the Open Records Act, when a request comes in, contemplates that the government has to spend 15 minutes basically for free. But after that 15 minutes, we get to pass along the cost of the lowest paid full-time employee that is equipped to be able to retrieve the documents. We get to basically pass along their cost to the requesting party. So you may say, okay, well, that seems like that would probably occur fairly early in the process, and I agree with that. And in fact, here's the key, and this is to you Open Records custodians and anybody else that is facilitating that, is when you get that request in the door and you are distributing it to the parties that need to generate the documents, or you are doing them yourself, you need to do an estimate of how long it is going to take you to produce these documents. Now, the word estimate is key, because if I had a nickel for every time when I have served in this role, when I have kicked out the open records to the various department heads and says, could you let me know what this is going to cost? And I get a response back that says, well, I've retrieved the documents and it took me like 7 hours to do it. See, there's a problem there, because when I hear like 7 hours and I hear the cost is $75 or $80, I have to put together what's called a pre-retrieval estimate. But the emphasis, folks, is pre-retrieval, because if my county and city staff have already retrieved the documents, then we've missed an opportunity to allow the requesting party to say, that's too rich, I don't want to pay that. So let me explain how it goes. The open records custodian gets the request in the door, sends it to the various department heads. The department heads estimate how long it's going to take their lowest paid full-time employee, less 15 minutes, to assemble the documents. Sure enough, it's going to come in at $50. We then, forget about the timetable for production just for a moment. We then get to write back to the requesting party and say, we have done a preliminary assessment of your Open Records Act request. We do have documents responsive. However, based upon this methodology of the lowest paid full-time hourly employee that is equipped to assemble the documents, we believe the cost to produce is going to be $50. And that cost to produce should include both labor and it should include costs like the cost of 8.5 by 11 copy paper at 10 cents per page. So you bundle all of that together, and then you send it to the requesting party and say, you need to let me know if you're prepared to be responsible for these charges. And you can delay the actual retrieval until they write back or otherwise manifest their willingness to be responsible for that. And that's important. And so don't miss that opportunity. And it serves very good public policy considerations. And it's really a benefit to the citizens, because really what it is the government saying, look, you're about to bake in a fairly hefty charge here. Are you sure that you want us to go and do this? And then if they say no, then perhaps you can work with them and narrow down the request such that the fees go down. If they say yes, then you'll begin your retrieval at that point. There is, as with all things, there's a caveat to that rule. And you'll see this a lot with attorneys. When attorneys are making the Open Records Act request, you'll see this paragraph at the bottom, and it'll say something like, please know we agree in advance to be responsible for $200 of costs. Okay, well, if they say that in the actual letter, you send the Open Records Act request out to your various departments, and then they come back and say it's going to be $75 or $50, you can't delay. Why? Because the requesting party has already told you they are prepared to be responsible for more than that. So I hope that makes sense. That is a caveat to that notion that we can delay until they confirm their willingness to pay. And then one additional final caveat, and that is that if in good faith, this is key, in good faith, you circulate the Open Records Act request and then you do the math on the pre-retrieval estimate and it comes in at more than $500, then we can ask for advance prepayment. If it comes in for more than $500. Okay. Keep going here. So again, I'm trying to sort of hit what this course is about. So the summary of options: within 3 days, produce the documents, or if the cost to compile and produce is less than $25, provide a date, a timetable when the documents will be ready. If the cost to compile and produce is more than $25 but less than $500, issue a pre-retrieval estimate and seek their permission to go forward. And then if the cost to compile and produce is more than $500, then we can require prepayment of the cost. And of course, if we require prepayment of the cost, they may say, I don't want to prepay, I withdraw the Open Records Act request, and I'm going to in fact narrow the request. Continuing forward with a little bit more about sort of the specifics of the fee shifting. How much do we charge? Interestingly, before 2012, the per page cost for copies was 25 cents. So in 2012, that actually went down to 10 cents per page. So we can charge 10 cents per page to generate copies. Now, one caveat here, I've had a lot of folks, particularly some of my more sophisticated open records folks, will say, I only want electronic copies. In other words, they don't want to pay the 10 cents per page. And don't get me wrong, the Open Records Act contemplates that we will attempt to provide records in the most economically feasible way that we can. So the law does not want us to say, well, we're going to print your piece of paper whether you want us to print it or not, because that way we get to charge you more. It doesn't really work that way. So if it can reasonably be produced without incurring fees, we have an obligation to try to do that. So we're not just trying to bake up and build up fees to stop compliance. So uniquely for me and the governments I work in, it's sort of been a little bit of a technological development that we used to, when we would get requests, particularly for electronic communications, we would have to print out the pieces of paper as a means of redaction. Well, now we have gotten some software where we do all the redaction electronically, and it's actually better because the Sharpie sometimes did not actually get the information off as well as it should have. So now we're doing that electronically, which means, however, we're not having to spend 10 cents per page to print that out to redact it. So just something to think about. There are software tools out there that can do the redaction very, very nicely and save everybody some costs. As I mentioned, I think in the prior slide, the first 15 minutes of search time is free. After that, you charge the hourly rate of the lowest full-time employee qualified to fill the request. The cost for non-attorneys to redact the exempted information can be charged to the requesting party. That was a development that came out of 2012 as well. That was a big deal. In fact, the original draft in 2012 would allow both attorneys and non-attorneys to pass along their charges, and needless to say, that did not make the final law. So it's only non-attorneys that can charge for redacting the exempted information. Yet another reason to have a Open Records Act specialized custodian. And hear me when I say this, not so we are building a bill that is unreasonable. It's mainly to ensure the government is treated fairly in this process as well, because these Open Records Act requests cost a lot of money, take a lot of resources to respond to. We all know this. I think the fee shifting is good, but I don't think it actually captures truly the cost. A lot of folks typically are having to taken off task to assemble this documentation. So to the extent that the Open Records Act allows us to build in legitimate costs for producing these documents, a government should take advantage of that. That's not being obstructionist. That is simply being intelligent and I think consistent with the act. We've already talked about estimating the cost of retrieving the records as part of assembling a pre-retrieval estimate. That should be done in good faith, not with an effort of trying to block an Open Records Act, but just ensuring that the government does in fact adequately estimate how long this is going to take and how much county or city resources are going to be spent responding. We can charge the actual cost of producing copies that are not letter or legal sized. I'm thinking of like maybe oversized plats or hydrology maps. Sometimes these are massive and have specialty printing apparatus to be able to print them. And we can charge the actual cost of that. Also, we can charge the actual cost of any media that we need to actually put the responsive information on. I'm thinking of like maybe a CD-ROM or maybe a USB drive. Yeah, we can charge for that. We can't make a profit of it, but we can charge whatever the cost of that media was. I've already mentioned this. An agency must use the most economical means to make records available. I've talked about that. If something can be legitimately and reasonably produced by way of a pure electronic production, we can't print out copies just because that creates a larger bill. We can't do that. We've talked about the second bullet point. That's good. We've already covered that topic of the individual that has to find the documents needs to be the lowest paid full-time employee that has the skill to produce them. So in other words, and the point they're trying to make here in the statute is if you've got a lower level employee that makes X per hour, but you decide that we're going to have the county manager rifle through the documents for 8 hours because he or she makes a lot more money, can't do that. It's supposed to be the lowest paid full-time employee that has the competence, the skill, the training to produce the documents. You should not charge for digital copies, of course, because there's really nothing tangible to charge there. However, and this is going back to my email illustration, if you had to copy records in preparation of digital copies, you may charge. And again, I ran into that for years and years and years. In fact, our transition to doing a pure electronic redaction is new. And so for years and years and years, emails, which are of course electronic, and the citizen requesting would not want to pay for redaction. And we would have to tell them, I'm sorry, but the only way we have to redact right now is to print them out, manually redact, rescan them, and then get them to you. And so you've got to pay that charge. So I don't know what your government is doing on that. If you have the software that you can skip the printing out process, if so, great. If not, you can still print out, redact, and then scan again and get them. Some special rules very quickly. Just because you happen to have use computer programs like Word or Microsoft Explorer or Excel, no one has a right under the Open Records Act to make a request for those documents. You can't get a free copy of Microsoft Word just because the government's using it. And records maintained by computers shall be made available where practicable by electronic means. So again, I hope you see a theme here from the Open Records Act, and that is government, you do get to fee shift and you get to charge citizens for this, but there is a real incentive that we want our citizens to have reasonable, timely, cost-effective access to their documents. These are taxpayer paid for documents and taxpayer funded governments. And so clearly the public policy in Georgia is we want our citizens to have reasonable access to those items, and costs should not be unduly increased for production. A little bit of a nuance here, but as an attorney that does a lot of litigation, this is near and dear to my heart. So does it ever happen that when plaintiffs particularly are suing the government, a county or city that otherwise is subject to the Open Records Act, and of course you all know that are on this webinar that there's going to be discovery as part of the litigation process, but discovery takes a long time, and the responding parties get 30 days to respond. Why not, rather than go through the discovery process, why not just send an Open Records Act request to that government you're litigating against and get the records that you otherwise would have, the other side would have 30 days to get. Now they've got less. And the answer is can they do that? The answer is yes. In fact, there's case law suggesting that civil discovery and the Open Records Act are two different things. And so just because you have the entitlement to civil discovery does not take away your right and entitlement to an Open Records Act request. But the law did change to allow some accommodations for us poor government lawyers trying to deal with defending our clients. And that is that a request made by a litigant who has pending litigation against a government about that litigation or about the subject matter of the litigation, first of all, must be in writing, and thank you, must be copied on the counsel of record for the agency so we know what they have asked of our own client. And then when the agency responds to the attorney or to the plaintiff that made the request, the agency has to serve those same documents on me. And the only exception to that is if I say I don't need them. But otherwise, you've got to provide them to me as well. And that way everybody's treated fairly, and I know exactly what my own government, my own client has produced to the other party. A few more things here. I know we're running lean on time, so a few more things here. First of all, what if the requesting party receives a pre-retrieval estimate, agrees to it, and then will not pay it? It does happen. The agency has the right to collect that unpaid for amount that it spent by any lawfully assessed by any matter authorized by law for the collection of taxes, fees, or assessments by the agency. So we do have the means of going to court and attempting to collect any amounts that have not been paid. I will tell you, having done this a minute, that is not typically how the government responds. It's actually the second bullet point that typically gets the most interest. If, in fact, a citizen came in, made an Open Records Act request, we sent them a pre-retrieval estimate, they said, yes, I'm in. We then go and collect all the documents, do the redactions, have the documents all wrapped up in a bow, let the requesting party know they're here, come pick them up, or what have you, or maybe even sent them electronically, now please pay us, and they don't, then until they get right with us on that unpaid for retrieval and production, then we can require prepayment for all future requests until such time as they pay the old one they didn't pay. So that's a real nice tool. And in fact, that is much more effective than suing anybody, because by the time you've gone through a collection process, you'll have spent more money than you will recover. But the second bullet point is very effective to get people's attention, that you gotta pay for that old one before we're gonna let you get any new ones that are not prepaid. Keep going here. Again, this is sort of self-evident, but nonetheless, sometimes it does need to be emphasized, and that is that we are not required to generate documents that do not exist. And so where you typically see this is a requesting party will ask for summaries or compilations of things that we've never done. Now, do we have the baseline documents that would be needed to prepare that compilation? Sure, we do. For instance, and just as a complete hypothetical, but say, I want to see for a 20-year period the line item budget expenditure on park and recs. Well, we don't have that document, but we have 20 years of budget documents with the line item for expenditures on park and rec. So typically what we would say to that requesting party is we're not required under the law to prepare you a compilation or a summary, because that document doesn't exist, but we do have all the budget detail if you want that. And then the citizen can create their own compilation or summaries. The only caveat I would give to this is this one, and it's just sort of not sophisticated, but it is a little unusual, and that is this. I don't have to tell anybody on this webinar we live in a digital age, and that a lot of the material that our governments have is digitized, is very manipulable, can be modified, can easily have reports generated. And I think what the law contemplates is, yeah, it's true, we're not required to create summaries or compilations, but if your government routinely generates reports manipulating digital data in the ordinary course, and a citizen asks for sort of a variation on that same thing, something that you would do in a heartbeat if it was requested by the county manager or the city manager, I think the law is going to contemplate that if you can do that and it's basically not out of the way, it's very normal, you should do that. I hope that makes sense, because so much of our data now is digital, and manipulating that digital data with just a couple of keystrokes it's everywhere. And so I think the law would take a dim view if you said, we're not going to provide that, even though it was 4 keystrokes away. That makes sense. Yeah, answering questions. So the Open Records Act is a mechanism for the production of documents. Now, when I say documents, we go back to that very second slide, and that the definition of documents is quite broad, includes electronic information as well. But it is not a conduit for citizens to just basically ask us questions, and sort of a written interrogatory to our records custodian or to our public officials. Now, do citizens write and ask questions? Yes. And do we have the right to answer citizens' questions? Well, of course. And do we, from time to time, answer those questions? Yes. I'm simply making the point here, though, that the vehicle, the mechanism by which we answer questions is not the Open Records Act. The Open Records Act is not a mechanism for citizens to sort of, this is my having fun with it, but not a mechanism for them to cross-examine my officials. It is a vehicle for the production of documents that are produced, prepared, maintained, and received in the scope and course of government operations. So maybe Dan will have me back someday, maybe not, but maybe will, and we'll talk about exceptions. This could be a couple of courses. And so OCGA 501872 contains all of the various exemptions under the Open Records Act, and I will tell you that it's not necessarily for the faint of heart. Some of it is reasonably understandable, some is less so. And I will even go so far as to say that with respect to exemptions under the Open Records Act request, 501872 is not the only statutory section that includes them. There are other areas of the code involving elections, involving juveniles, involving the court system, involving other areas that also provide that it's not subject to the Open Records Act, but it's not found in 501872. So I will say this, if you ever get into a situation where you are struggling with whether you're doing redactions correctly or whether you have a particular piece of information you're not sure if that can in fact be released, I do recommend you check with your city or county attorney and make sure that you're comfortable releasing that information. And I know that may be an unsatisfactory response, but it's the best one I've got because this can be challenging. I will also tell you that the law contemplates that if there is information in a document that is both releasable and not releasable, in other words, it's a mixed document that contains information that should be redacted and then the rest of the document is fair game, then we have to do that. We have to redact and release the remainder. Okay, we have to redact and release the remainder. And I put on the screen in front of you just a couple of situations where that's really evident. For instance, we have a lot of documents that may include social security numbers or driver's license number, personal cell phone, personal email address. In most of the situations where that is the information, that is the exception, that's the confidential information, then we have to release the rest of the document. So it will go out with either a redaction on it or some sort of a electronic redaction as well. You know, again, we could go into a full course on this, but medical records, any information that might in fact constitute an invasion of personal privacy has to be exempted. We all understand HIPAA and the impediments of HIPAA with respect to releasing private personal health information. Documents required to be kept confidential by federal statute or regulation. I think I had mentioned that one earlier. That's just a bit of a mouthful right there. There's a lot going on in that one. And we typically see that a lot of times, particularly with respect to driver's information that can be implicated. Security exceptions, records, the disclosure of which would compromise security against terrorism. And again, I always like providing to the best that I can sort of real life examples. So one of the things that uniquely a county government has to produce is what's called a courthouse security plan. And that is in fact a plan that identifies vulnerabilities perhaps in the courthouse and then ways those vulnerabilities will be met with law enforcement or security measures. Well, needless to say, if that document was released, then we have just made our courthouse more vulnerable. So that is the sort of thing that would be protected under the Open Records Act, maybe vulnerability assessments with respect to your utilities. Obviously, terribly, terribly important information, and that would be the sort of thing that could in fact be protected. Records of confidential evaluations in connection with the appointment or hiring of a public officer or employee. And just as a way of an example, there have been situations where there may even be mental health screenings with respect to certain individuals or hires, and those can be obviously withheld. Records related to the suspension, firing, or investigation of complaints against a public employee. And I think that was actually a response to one of the earlier questions I got about I thought it had to do with maybe bullying. And so to the extent that there was an investigation into reports that a county or city employee had bullied or harassed someone, then that investigation would in fact be protected until 10 days after presentation to the agency or officer for action. And again, I think I had mentioned that the report would be released to the city manager or the county manager or the board of commissioners or the city council, and they needed a little bit of time to be able to take action before it is released publicly. A few more, and we're about to wind down here, just a few more, but I don't know that I need to go through all of these, but these are just some of the sort of the low-hanging fruit on 501872A20A, and this has to be removed from all records. The first couple of bullets there on the left, the reason for that is for time immemorial, particularly the mother's birth name or maiden name, was sort of a typical security screening question that a lot of folks would have to provide. And so if that was released, then it would make identity theft easier. I don't have to tell you why Social Security numbers are as protected as they were, although I will tell you that when I was growing up, that was on my checks. My checks had my Social Security number on it. And of course, now it's considered very, very unwise to release that to anybody. Personal email addresses and cell phone, again, that's personal, both personal and personal cell phone. Unlisted telephone numbers, very difficult to understand if they're unlisted or not, if they're on county forms, but nonetheless, that's the rule. Credit and debit card information, account numbers and passwords, utility account information, financial data or information. Don't have to tell you that one, financial data or information, is a bit broad and has a little bit of subjectivity to it. So that's always a little bit of a difficult one to interpret. Insurance or medical information, I'm sure that's self-evident. Day and a month of birth, again, that goes to identity theft, and obviously bank account information. So again, those are just sorts of, that information. If you see it, you're gonna have to remove that. And then there are equal, but actually additional prohibitions with respect to public employees. So it's the list prior, okay, plus these. And that gets into the notion that people that work in government have some unique vulnerabilities, and therefore there need to be some unique protections. And so that's just an additional food for thought. I will tell you there is one sort of an interesting nuance on this one, though, is that this ability to do additional reactions for documents that contain information about public employees, the statute says that the paragraph shall not apply to public records that do not specifically identify public employees or their jobs, titles, or offices. The point being is that the record that can be subject to these additional redactions has to actually name the individual as a public employee by their job or title or office. Okay. Dan, I think we're getting close here. I can go over these tips very quickly and get into enforcement. So let's do the tips first. I think I'm going to skip enforcement. Those slides are in the package and you all have those. But I just want to finish up with these tips because I know I'm running over, as I am wont to do. But tips, first of all, if you're doing particularly electronic queries based upon an Open Records Act request that has come in, I'm a big believer in letting the requesting party know what terms and how we structured them, how that was done. That way they're on notice of it, I'm on notice of it, and when the request perhaps generates 10,000 emails, they can't be upset with us because we ran the query that we had told them what they were going to run based upon the information they provided us. I think it keeps everybody better informed and accountable if there is some sort of a communication of how we ran the searches, what terms we used, what mailboxes we looked into, etc. Another tip, talk to staff first about which employees may have records or emails, etc. And here's my point. If we get a request in and it's for a particular subject matter and there's keywords, rather than doing a search of the entire email system of our government, if I know that there are 15 employees that are most likely the employees that would have touched that matter, then I will typically ask my IT folks to run the search only for those employee mailboxes. Now wait, I will tell the requesting party I limited it that way too. And that's me attempting to say, look, I think what you're looking for, these are the individuals that touch that. But if we do this countywide, I'm going to generate 30,000 emails. and you're not going to be happy, and you're going to feel frustrated. So I'm just going to go ahead and try to figure out who I think are the better individuals. Again, do you have to do this? No. This is what I would call sanity tips for me. This is not mandated by the act, but these are just things that have proven effective to me, having done this for a few decades. Be realistic about staff time limitations. Yeah, I mean, and this is we have to constantly monitor this on our end as the lawyer, is that, you know, the good folks in the various offices, open records custodians, the clerks, whomever it may be. I mean, they've got probably 15 other jobs they're attempting to do every day. And then here we come in knocking with a big new Open Records Act request that somebody has sent to us or somebody has sent to them. And so I would just recommend this, you know, good faith is key, you know, trying to be reasonable in how we frame how long it's going to take to produce. But on the other hand, let's be realistic. I mean, if you do not have the resources to respond in 5 days, then let's don't give them a time frame of 5 days. Let's give them 10. I would rather go to the well, in other words, tell that party just one time what the production is going to be, than continually getting extensions, because we can't meet the first deadline we gave them. And yeah, this last tip, and Dan, I think I will end with this one, and that is, folks, I kind of mentioned this earlier, but as people begin to do more and more and more and more business online and expect more from their governments online, big believer that the more we can have online is absolutely ideal, and it will save us Open Records Act. Now, obviously, there is a front end cost to that. I know the documents we make available online, and for most purposes, need to go ahead and have the redactions built into them, so we're not putting out information online that otherwise would not be allowed to be subject to an Open Records Act request. But if you can have your government sort of pivot to sort of having this more robust online presence of documents, I think that it will make your Open Records Act compliance much more manageable. So I have been talking a minute, and I know there are probably a lot of questions. And Dan, you tell me what you think. I'm happy to respond to as many.
First of all, Ken, I think you did a great job. I'm sure you're not able to hear it, but people are standing up applauding for the fantastic presentation that you've provided. I do have questions, but because of time, if it's okay, I'm going to send those to you. And if you could, so if everybody has questions, please just send those to me email. I'm going to send those to Ken. He'll respond to those all at once. And when I send out the recording, and you're going to send me the presentation, Ken, or I think you already did send me the presentation.
Yes.
I'll be sending that out with the link to the recording also, so you'll all be able to see that. So just send me via email if you have any additional questions. And thank you so very much. You knocked it out of the ballpark, Ken. Fantastic job. I'm sure this will probably hit 1 million hits on YouTube, I would assume.
Well, hey, hit the subscribe button because I'm pretty sure that gets monetized.
Yeah, we will start monetizing that. So thank you so much, everybody, for your participation. Here's applause. Thank you. Great presentation, Ken. Will the PowerPoint? Yes, the PowerPoint will be available. What counties have their information online? I'll add that question to the list. Thank you, guys. Thank everybody so much. Really appreciate it. We will talk to everybody later. Thank you, Ken.
Thanks, guys.